We make promises all the time, right? I'll pay you back next week. Sure, I'll help you move. Simple stuff. But have you ever stopped to think about what separates a casual promise from one that's, well, legally bulletproof? What's that invisible line that turns an I promise into something a court will actually enforce? Well, that's exactly what we're going to dive into.
So yeah, this is the big question. What's the real difference between a friendly handshake and an ironclad deal that you can count on? The answer, you'll see, is all about the system we've built to bring some order to all our promises.
At its very core, that's what law is all about, creating order so we can all function together predictably. And when it comes to agreements, the law is what gives us the confidence to trust that when someone makes a serious promise, they're actually going to have to keep it. Think of it as the ultimate backup plan.
Okay, so what is that magic ingredient? What's the secret sauce that transforms a simple promise into a real bona fide contract? It's actually pretty straightforward, but you've got to get the recipe exactly right.
This slide just lays it out so clearly. An agreement, that's just an offer plus an acceptance. Simple. But a contract, that's a whole different beast. It's the agreement plus this critical ingredient, legal enforceability. And that's the part that really matters, because it means if the other person bails, you've got legal backup. You could say a contract is basically an agreement with teeth.
To get that legal backup, your agreement has to pass a sort of test. I like to think of it as a checklist for building something solid. If you can tick all the right boxes, congratulations, you've built a contract the law will actually protect. So what's on the list?
Here they are, the essential building blocks. First up, you need a clear offer and acceptance. No ambiguity. Second, and this is a big one, both sides have to actually intend for it to be a serious legal deal. Third, there's this thing called consideration. Don't worry, we're going to dig into that one in a sec. You also need people who have the legal capacity to make a deal in the first place. They have to give their free and genuine consent, and the whole point of the deal has to be lawful and clear.
All right, let's talk about consideration. This is pretty much the heart of any real contract. It's the what's in it for me part of the deal for everybody involved. See, a contract is an exchange. It's not a one-way street, not a gift. If I promise to paint your house, your promise to pay me money, that's the consideration. It's this two-way value exchange that makes it a legally serious bargain.
And that brings us back to intention. The law actually has a default setting here. For business deals, it just assumes, yep, you folks meant for this to be legally serious. But for promises between, say, family or friends, the assumption flips completely. The law figures you probably didn't intend to sue each other. And the classic case for this is Balfour versus Balfour. You had a husband who promised his wife a monthly allowance. Sounds nice, right? Well, they separated, he stopped paying, and she took him to court. But the court said, nope, not a contract. It was just a domestic arrangement. Why? Because there was no intention to create a legally binding deal from the get-go.
Next up is capacity. This is pretty straightforward. The law basically protects certain people by saying they can't be locked into contracts. Generally, this means you need to be an adult, you need to be of sound mind, and you can't be disqualified for some other legal reason. And what if you didn't really agree? I mean, a contract is only valid if everyone enters into it willingly. If somebody was forced or tricked or flat out lied to, well, their consent isn't genuine, and the law is not going to enforce a deal that was built on pressure or deception. Simple as that. So let's say you did everything right. You ticked all the boxes, you've got a valid contract. Awesome. But what happens when someone doesn't do what they promised? Well, this is when things get serious. This is the breaking point. When one party just fails to live up to their end of the bargain, and they don't have a good legal excuse, it has a name: breach of contract. And that action is what triggers the whole legal system to step in and find a solution.
Now, a contract status isn't always set in stone. A breach, or even finding a flaw in how it was made in the first place, can actually change its legal standing. For example, a perfectly valid contract can suddenly become something called voidable.
A voidable contract is a really interesting situation. It's a valid deal on the surface, but one person, the wrong party, has the power to hit the escape button. This usually happens when that consent we talked about wasn't freely given. Maybe they were pressured into it. So that person gets to make the call. Either we enforce this thing, or we cancel it completely.
When a contract is broken, the law doesn't just, throw its hands up. It provides actual solutions, or remedies, designed to fix the problem and make the injured party whole again. So let's take a look at what those are. These are the main tools in a court's toolbox. They can order rescission, which basically just wipes the contract out. They can order specific performance, which forces someone to do the exact thing they promised. They can issue an injunction to stop someone from doing something. But honestly, the most common remedy by far, it's damages, good old-fashioned money.
And this quote right here just nails it. The whole point of awarding damages isn't to punish the person who broke the promise. It's all about compensating the victim. It's about using money to put them back in the financial position they would have been in if the contract had just been followed through on.
And damages aren't all the same either. You've got ordinary damages, which cover the direct, predictable losses. Then there are special damages for unique losses that both sides knew could happen if the deal went south. You've got nominal damages, which are symbolic, like a $1 award just to prove a point. And then, in really rare cases, a court might award vindictive or punitive damages, which is specifically designed to punish truly awful behavior.
But there are limits. A super important case called Hadley versus Baxendale set a crucial rule. You're only on the hook for losses that were a reasonably foreseeable result of you breaking the contract at the time you made the deal. You can't be held responsible for some wild, unpredictable chain reaction that nobody could have possibly seen coming.
And that really brings us to the big takeaway here. Now that you know the building blocks, the intention, the consideration, the consent, you can really see the difference. So, the next time you shake on it, just ask yourself, is this just a casual promise, or are we building something that the law will actually stand behind?